Welcome to Season 5 of Public Health on Call, a podcast from the Johns Hopkins Bloomberg School of Public Health. I'm Joshua Sharfstein, Vice Dean for Public Health Practice and Community Engagement and a former health commissioner here in Baltimore, Maryland. Our goal with this podcast is to bring scientific evidence and experience to shed light on critical health issues. If you have questions or ideas for us, please send an email to publichealthquestion@jhu.edu. That's publichealthquestion@jhu.edu for future podcast episodes.
Hi, I'm Lindsay Smith Rogers, producer of Public Health on Call. We'll be off for Memorial Day and return on June 1st with Season 6. This summer, we'll continue to talk about living with COVID and the shift from pandemic crisis to endemic virus. We'll also continue to follow breaking news around new variants, the future of reproductive health and the Supreme Court, and humanitarian crises in Ukraine and around the world. We'll look at other urgent public health issues, including racism, gun violence, mental health, climate change, and overdose. And of course, we'll continue to cover the need for investments in public health infrastructure and surveillance for future pandemic threats. As we wind down Season 5, we have a few thank yous. First, huge thanks to our interns, Crystal Allen, Hannah Bennett, Maisie Conrad, and Caroline Wang, who bring fresh ideas and much needed support for the podcast. We'd also like to thank you, our listeners, for sharing your ideas and questions and for downloading this podcast more than 7 million times. We appreciate all the great ideas and questions that come from our listeners. So keep writing to us at publichealthquestion@jhu.edu. That's publichealthquestion@jhu.edu. And thank you for being part of this podcast. Today, we turn to reproductive health and the right to an abortion. A few weeks after the unprecedented leak of a draft Supreme Court opinion that would overturn Roe v. Wade, Joanne Rosen of the Johns Hopkins Bloomberg School of Public Health speaks with Dr. Josh Sharfstein about what comes next for the law and for public health. Let's listen.
Joanne Rosen, thank you so much for coming onto Public Health on Call to talk to us about this leaked draft Supreme Court opinion, which may overturn Roe versus Wade. That's what the headlines say. This is an area that you've worked in and thought about a great deal. How did you read this draft leaked opinion?
Just as you've described it from the headlines, it looks like there are 5 justices on the Supreme Court who are prepared to reverse Roe versus Wade and a really important follow-up case of the Supreme Court, Planned Parenthood versus Casey. It's the first draft. The date on it is February 10th, but the position of the court is unambiguous. In this opinion, the court says that Roe was egregiously wrong, that it was egregiously wrong from the very start, that the reasoning is exceedingly weak, and that there is not in the Constitution a right to decide whether to abort or terminate a pregnancy. So it is a full repudiation of the constitutional precedents that have protected the right to make decisions about whether to continue a pregnancy.
And written not perhaps in the most humble tone you could imagine.
So that was the other thing that really struck me when I read the opinion. Actually, first was the fact that it was leaked. This is the first time, I think, in history that a draft opinion, a working draft, has been released to the press and the public well in advance of the final opinion being published. Second was the content, of course, and the tone. It is a very forceful, strongly worded, almost angry kind of opinion written by the court. It's the kind of tone that I'm more familiar with in dissenting opinions, in the decisions that are written by the justices who would have decided the case the other way and are angry because they think that it was wrong. That kind of forceful, aggressive, very strong tone is not what you usually see in opinions of the court. It's what you usually see in dissenting opinions.
Well, it certainly has caused a shockwave of realization that abortion rights are very much at risk. And the consequences of an opinion like this would be pretty immediate in many parts of the country. Could you talk about how the Supreme Court's decision would affect what can happen at the state and local level?
Sure. So there are many states in the country that have long been preparing for the possibility that Roe would be overturned. And some of these states have what are known as trigger laws, laws that are already on the books and that will come into force and ban abortion immediately in the event that Roe is overturned. There are, according to Guttmacher Institute, 25 or 26 states that either have trigger laws or through some other mechanism would be poised to ban abortion pretty much immediately if Roe is reversed. Then there are 15 states and DC that have laws in place already that are protective of abortion. And of those states, a small number, Maryland is included, as well as Connecticut and California, in the most recent legislative sessions. And in anticipation that this Mississippi case could, in fact, reverse Roe, some of these states have introduced more extensive protections for abortion, again, on the understanding that if Roe is reversed and these 26 other states immediately ban abortion, there will be transit. Women will travel from their states to these protective states. Then we have a smaller number of states that are what I might call hybrid states. They are not set to ban abortion outright, but nor are they protective of abortion. They are sort of in the middle. So Florida is one of these states. Illinois is another. Florida has introduced a 15-week ban, but they don't appear ready to ban abortion altogether. So those are kind of the immediate ramifications of a reversal of Roe.
Now, these laws that might take effect, particularly the ones that would reduce access to abortion, have a range to them. Some of them might be the 15-week version, like you talked about. Others go further. Could you talk a little bit about the differences between those laws?
Sure. So prior to the Dobbs case, this Mississippi case, many states had introduced laws that were pre-viability abortion bans, laws that violated the central premises of Roe and other abortion cases. And they had all been enjoined or halted from going into effect because they were so clearly unconstitutional. There were 6-week bans, there have been 8-week bans, there have been some 20-week bans that have been allowed to go into effect. Those were usually fetal pain bans. So yes, there have been a range of abortion restrictions that haven't banned abortion outright, but have severely restricted or curtailed access. The one exception that I want to raise that's already in force, it's probably known to some of your listeners, is Texas SB 8, which came into effect on September 1st. It's a 6-week abortion ban. And because of a novel and very deliberate kind of enforcement mechanism, despite the fact that it is clearly unconstitutional, it has been allowed to go into effect. So Texas has been operating as if Roe were reversed since September.
And the laws may go further. The laws may ban abortion altogether if Roe is reversed.
They would be permitted to do so, yeah.
And I wonder whether you're seeing any patterns in terms of whether there would be exceptions, for example, in cases of rape or incest, or also limits to who could be charged. Is it just the person providing the abortion? Is it the person getting the abortion? What's the range of things that could happen?
So I think it's really up for grabs. There's a wide range. The Mississippi law at issue in Dobbs does not contain exceptions for pregnancies that are the result of rape or incest. It has been, I think, more typical to see those exceptions. There are always exceptions for instances in which continuation of the pregnancy threatens the pregnant person's life. I don't know whether there will also be exceptions for pregnancies that threaten the pregnant person's health. Under Roe and Casey, states are allowed to ban abortion after viability, so long as those bans include exceptions for the woman's life or health being imperiled. But if Roe is reversed, those exceptions would be left to the state. One of the things that the draft opinion says on this point, abortion restrictions will be evaluated in the same way that any other health and welfare restrictions are currently evaluated, which is to say, under a much lower, much more deferential level of scrutiny. And the court does say in the Dobbs leaked opinion that there will be a presumption that these laws are valid, any abortion restrictions, just in the way that other health restrictions are presumed to be valid, so long as the court has a legitimate interest. And the court says that one legitimate interest for the state in banning abortion or restricting abortion is to try to protect fetal life from the very beginning of pregnancy. So that clearly would allow a ban.
The draft opinion also raises some really difficult questions for the relationship between states, because as you said, there are some states that may want to stop all abortions and others that may want to protect people getting abortions. And there may not be such an easy dividing line between them. How do you see that playing out?
Absolutely. So one of the issues that's really alive right now is whether a state that bans abortion may try to extend its reach extra-jurisdictionally and prevent people who live in that state or reside in that state from going to other states where abortion is legal to get that abortion. And this is pretty much uncharted territory. We'll have to wait and see. There are legal arguments that a state cannot extend the reach of its criminal law into other states, but those are some of the methods that are being discussed and could be on the table in some states. So that even though their criminalization will only take place in their state, attempts to try to prevent people from leaving that state and going to other states, or prevent them from returning, or asking people questions about the purposes of their travel out of state, or the purposes as they're coming back into state. This is all within the realm of legislative activity that states might try.
Now, you, in addition to being a lawyer, are also a faculty member at the School of Public Health. How have you thought about the public health consequences of what might be in store?
We can speculate, but we already actually know. We know that 75% of the people who currently get abortions are either low income or poor. And the reasons for seeking abortion often have to do with not having the economic wherewithal to take care of another child, to take care of this child, a lot of economic disruption. So the consequences of creating a constitutional green light, which would allow states to go even farther than they have in regulating abortion, will largely be borne by women of low income. We also know that African American and Latinx women have abortions at higher rates than non-Hispanic white women. And again, the intersectionality of poverty or low socioeconomic status and race are also at play. So again, we know there are already profound health inequities on the ability to control reproductive autonomy and to raise children well. If Roe is reversed, it will deepen and exacerbate these existing health inequities.
Joanne Rosen, thank you so much for coming to talk to us about these important questions. I have a feeling we will be talking again on the other side of the looking glass about these same issues.
Thanks for having me, Josh.
Public Health On Call is produced by Joshua Sharfstein, Lindsay Smith-Rogers, and Stephanie Desmond. Audio production by Niall Owen McClusker, Matthew Martin, Spencer Greer, and Holly Cardinale, with support from Chip Hickey. Distribution by Nick Moran. Production support from Catherine Ricardo. Social media support from Grace Holz Fernandez. Thank you for listening.